Okay, I think I'm recording. Hello there, Scott Gerber. How you doing?
Morning, Glenn. I'm fine. How are you?
I'm doing very well, thank you. Glenn Loury here at Brown University and bloggingheads.tv, The Glenn Show. I'm professor of economics and of social sciences here at Brown. The Glenn Show is sponsored by Brown's Watson Institute for International and Public Affairs. And I'm joined today by Scott Gerber, who is a professor of law at Ohio Northern University and also a visiting professor with the Political Theory Project here at Brown University. So indeed, Scott is my colleague. And in fact, he's sitting right across the alleyway from me, less than a stone's throw away. Scott is a legal historian and constitutional lawyer who writes academic books about, among other things, the connection between the Declaration of Independence and the U.S. Constitution. He's published, as I say, 5 books, many articles, essays, and reviews, and has in particular written about the jurisprudence of Justice Clarence Thomas, and that's why I invited Scott to join me in discussion here at the Glenn Show today. The book is called First Principles, the Jurisprudence of Clarence Thomas. Scott's also the author of, again, I say, among other things, the Declaration of Independence and Constitutional Interpretation. So, Scott, I have to confess, and confess to the audience as well, that one of the reasons I was really motivated to talk with you about Justice Thomas's jurisprudence is that it strikes me that in some quarters of American public opinion and discussion of political affairs, Justice Thomas is kind of caricatured. I mean, what you know about Justice Thomas is the Anita Hill controversy surrounding his confirmation, or what you know about Justice Thomas is that he went years and years and years without asking a question during oral argument from the bench of the U.S. Supreme Court, or what you know about Justice Thomas is that he's a clone of the late Justice Antonin Scalia and is voting with him in a kind of lockstep manner without having an independent view. And I think this caricature is profoundly unfortunate. This is me, Glenn Loury, editorializing for a moment. Thank you for allowing it, Scott, because you're the expert. But I think it's profoundly unfortunate in view of the fact that Justice Thomas, I mean, he was confirmed, as I recall, in 1991. That was 28 years ago. He's been sitting on the Supreme Court for a very long time. I mean, in fact, he's the dean of the conservative wing of the Supreme Court in terms of longevity. And he has had clerks who have spread throughout the American legal, academic, and administrative establishment, and he has written opinions, and he has obviously had an imprint. Now, I'm not an expert, but I was hoping that we might be able to at least help to contribute to a more well-informed public discussion about the career and the influence of Justice Clarence Thomas by talking with you somewhat about his jurisprudence. Why don't we begin by you telling us how it is that you came? I mean, Thomas is a notorious figure in the legal academy, as far as I can tell, tends to lean a little bit left of center. How is it that you came to take up this project of writing a book about the jurisprudence of Clarence Thomas?
Well, the origins of it are that I was in graduate school at the University of Virginia, founded by Thomas Jefferson, author of the Declaration of Independence. And I was writing my PhD dissertation on the relationship between the Declaration and the Constitution. And as you mentioned in the introduction, that became my first book. And while I was writing that, I was still in grad school, as I mentioned. Clarence Thomas was nominated to the Supreme Court by the first President Bush. And given who Clarence Thomas was at the time, a judge on the D.C. Circuit Court of Appeals, and who he was likely to become, i.e. a member of the highest court in the land, I just wanted to know what he thought about that relationship between the Declaration and the Constitution, because I had read in the newspaper that he was interested in it. So it was as simple as that. And given all the attention that he was getting during the confirmation hearing, someone encouraged me just to write a quick little essay about his thoughts on the Declaration of Independence. And I did that, again, as a graduate student, and the University of Virginia pre-released the essay and, to the media, and the Senate got a hold of it. And so I was quoted as a grad student in the Senate, which was bizarre.
Hold on. During the 1991 confirmation hearings,
yeah.
you were quoted as a legal scholarly expert on the qualifications of Clarence Thomas for the Supreme Court?
Well, I was quoted on his writings about the Declaration, yes. Senator Paul Simon quoted me, or misquoted me is more like it, but nevertheless mentioned my name. And then I was getting phone calls from the newspapers and everything. And luckily, Virginia is the home of Loury Sabato, who's very skilled with the media, and he was giving me advice about how to deal with the media. So that's how it started. And then after my first book, which was my dissertation, was published, my editor, Nico Fund, who's now the president of Oxford University Press, thought that I should write a follow-up book, sort of a sequel to the first one, and this one would be about Justice Thomas.
Well, let me just ask you, because the late Senator Paul Simon of Illinois was a Democrat, as I recall. I don't know that he would have necessarily been supportive of Clarence Thomas's elevation to the Supreme Court. So when he quoted you, was it his ammunition against the fitness of the judge to be justice?
Yeah, I think that Senator Simon realized that I wasn't trying to derail anything. I was just writing something. And he sort of said, I saw this thing and I don't care what it said. Some young person said this about his commitment to the Declaration. And then he just went on and gave a political speech.
I see. Anyway, you were about to say something.
So my editor at NYU at the time, Nico Fund, who's now the head at Oxford, he thought that an early look at Justice Thomas's legal theory would be useful because at the time, all that there were books about the Anita Hill controversy. And so I actually wrote the first book about Justice Thomas's legal philosophy. And then because of how captivating he is to so many people, that then led to speaking invitations and things like that.
I see. What year did your book come out? First Principles, the Jurisprudence of Clarence Thomas?
Yeah, the first edition came out in 1999, and so it was his first 5 years. It was what political scientists would call an acclimation period look. The first 5 years are usually regarded by judicial behavioralists as kind of a formative period. And so that was sort of an excuse for writing an early look at that. And then it was updated in 2002 with his next 5 years. And then I've moved on to many other things, but occasionally I'll get asked to participate at a law school symposium about Justice Thomas. And so I'll then update my work through law review articles and talks and all of that. And then occasionally I'll write an op-ed about him and the like. And someday when I get done with this colonial legal history I'm doing, I'm going to, sit down and update the book itself again about Justice Thomas.
But you're saying that already after a mere 5 years on the court, there was a distinctive character, an outline that could be discerned to a Clarence Thomas approach to interpreting the Constitution that was his own.
Right. On civil rights cases, he appealed to the Declaration of Independence's ideal of inherent equality. And he was unique in that. And he stayed true to that. And so people always want to know, how can an African-American judge oppose affirmative action, for example? Well, he opposes it because he believes that the nation was founded on the idea that individuals as human beings have certain inherent rights, and they should be treated as individuals and not members of racial groups. And so that was distinctive out of the gate.
Now, this idea about individuals and not groups is clear in the Declaration, but not in the U.S. Constitution?
No, my first book, To Secure These Rights, the one that you mentioned, and the subtitle is The Declaration of Independence and Constitutional Interpretation. In that book, I argue that the Constitution is the political architecture that the framers enacted to effectuate the philosophical ideals in the Declaration of Independence. So I think that Justice Thomas is right about that. And so the Constitution is the structure and form of government, and the objectives of the regime are in the Declaration.
And the bearing of that fact, let me stipulate it, on constitutional interpretation is what?
I believe that the Constitution should be read in light of the Lockean liberal principles of the Declaration of Individual Rights, that we're all human beings endowed with individual rights. To secure these rights, Jefferson proclaimed in the Declaration of Independence, governments are instituted among men. So limited government whose primary purpose is to protect individual rights.
Okay, that's an ideal articulated brilliantly by Jefferson in the Declaration of Independence. I'm asking the question about why or how we should use that idealization when confronted with the text of the Constitution. This is something about intention or meaning or, sort of implicit purpose of the Constitution that we derive from reading the Declaration, and that should color how we actually execute the imperatives of the Constitution. This is what I'm trying to understand, the linkage between those two things.
Yeah, exactly. And again, the first part of my first book is called The Jurisprudence of the American Founding. And there I look at the framing and ratification debates, the Federalist Papers, early state constitutions and Bill of Rights, early judicial decisions, i.e. by early, I mean those that preceded the U.S. Constitution. And I demonstrate, at least in my opinion, that the framers wrote the Constitution with the same commitment that the Constitution is designed to advance the Lockean liberal principles articulated in the Declaration of Independence. So I just go through methodically the quote evidence to support that view.
So I'm not a legal scholar. I want to make that very clear, and I may say some things that don't make sense here. Please don't hesitate to correct me. But the question in my mind is, must there not be many practices, not only something like racial preferences and group, ideas, many practices like the structure of the American welfare state, like taxation or law about property or whatever, many practices that are, at least to some degree in the 20th, 21st century, at variance with, quote, Lockean principles, close quote, which liberal principles I would take to be sort of maximally protective of property rights, skeptical about government intrusion in one way or another. So if we're going to interpret the Constitution in the year 2019, at least in part, by reference to the purported Lockean principles that animated Thomas Jefferson in 1776, what else is going to be wiped out after you've wiped out any consideration of group membership, identity, racial heritage, history, or whatever? What else is going to be endangered by taking a 17th century or early 18th century philosophical posture toward constitutional interpretation? Why shouldn't I be a little bit skeptical about that move? Why isn't that, to some degree, a kind of ideological imposition? It's not Lockean liberalism, it's Hayekian liberalism that's sticking its nose under the camel's nose under the tent of Constitution. You see what I'm getting at? I'm sure that this is a critique that some critical legal theorists will elaborate on more effectively than I can. But you see where I'm going with that?
Yeah, I'll just say two things about that. The reason I was interested in the Declaration of Independence was because I was taking a seminar in grad school taught by the great Henry Abraham, and we were reading all of these classics in constitutional interpretation, John Hart Ely's Democracy and Distrust, Ronald Dworkin's Law's Empire, all of that. And these are very smart people, and I found their arguments interesting to read. But at the end of the day, it seemed like all they were trying to do was dress up their own political values in the language of law and impose them on, or try to impose them on, the rest of us. And so I wasn't comfortable with that. But I did agree that the Constitution is written in general terms. The parts that we care about are written in general terms. And so it's unavoidable that political philosophy and political values impact how we would read the document. And so what I tried to do was decide, okay, what political values have we as a nation agreed to? And so that's what led me to the Declaration of Independence. And then I had to decide, okay, so what political values are articulated in the Declaration of Independence? And believe it or not, scholars have disagreed with that over the years. Gary Wills won the Pulitzer Prize, I believe, for arguing that the Declaration is not Lockean liberal. And so I disagreed with that. And in the first chapter of the book, I tried to describe why I think the Declaration is Lockean liberal. And so if readers are convinced that I've rebutted someone like Gary Wills, then they might be willing to read the next chapter, which, as I've already described, tries to persuade readers that the Constitution embodies those values and is simply the political structure to advance them. And now to your question.
Thank you.
The most obvious thing that would be at peril, if you want to use that word, would be the modern administrative state, right? And Justice Thomas thinks it should be at peril too, by the way, because we're supposed to have a limited government, not one that can do just about anything it wants. And Richard Epstein, the famous libertarian law professor at NYU now, but most of his career at the University of Chicago, he wrote a famous article in the Chicago Law Review attacking the Commerce Clause jurisprudence of the Supreme Court, the modern Supreme Court, by saying that Congress should not be allowed to do anything it wants through the commerce power, which is in fact what Congress has used it for, right? And so if you look at a lot of the major legislation that we live under, environmental protection, civil rights protection, that sort of thing, those are enacted through the commerce power. And that doesn't mean that you have to be opposed to civil rights if you think the commerce power is being used too broadly by the Supreme Court. It just means that a different part of the government, the state governments and the local governments, should be charged with protecting those rights. The national government doesn't have a police power. They don't. But under the commerce power, they do.
Okay. Now, again, correct me if I'm off base, but what I'm getting from this is that marrying the Declaration in the spirit of Justice Thomas to constitutional interpretation, using these fundamental ideas about limited government and Lockean liberalism as the lens through which to view the Constitution, would invalidate much of the contemporary administrative state. I'm talking about the Environmental Protection Agency. I'm talking about the Occupational Safety and Health Administration. I'm talking about, I assume, the Security and Exchange Commission and things of this kind. And you say that, well, that doesn't mean we don't care about these things, the Equal Employment Opportunity Commission and so on. It doesn't mean that we don't care about these things. It just means that our Constitution doesn't empower the federal government to take these matters up. But I can see a certain critic saying, of that point of view, saying, well, look at, we have by incremental advancement through decades and generations developed a way of, regulating protection of the environment, workers' rights, the equal citizenship for our people and whatnot. And you now want to overthrow that. These are settled matters, are they not? You now want to undo this. You're a radical. You're trying to smash the temple, turn over the tables and whatnot. Again, I smell political motivation. You cloak yourself in some kind of purity of constitutional interpretation of philosophical idealism. But what I smell is an antipathy to the New Deal, a hostility toward the political evolution that made the United States into a social democracy, such as it is, as opposed to being a laissez-faire, every tub on its own bottom, every person for itself kind of society. You want to undo that. You want to take us back to the 19th century.
Yeah, I'm a legal historian and theorist. I'm not a policymaker. So I just try to go where the evidence leads me. Justice Thomas is more cautious than how you're portraying me. For example, it was U.S. v. Lopez in 1995, where he said that the New Deal jurisprudence that we're talking about is wrong. He didn't say, though, that we should overturn it. He realizes what you've said, that precedent matters and that, we've grown accustomed to this system and all of that. So he didn't quite go as far as to say, I therefore demand that it be reversed. Sometimes he says that, but on this particular issue, he hasn't quite said that. But if you're looking at it simply as an idealistic theorist and as a historian that tries to take the record seriously, I think you would have to, get rid of it.
Okay. Can we circle back to talking about Justice Thomas's jurisprudence as it relates to questions of race and racial equality, desegregation, affirmative action, voting rights? Because, of course, Thomas replaced Justice Thurgood Marshall on the U.S. Supreme Court when he was appointed. He was an African-American replacing an African-American. Justice Thurgood Marshall had been, as everybody knows, a crusader for civil rights and litigating, and was elevated to the federal bench by Lyndon Johnson and to the Supreme Court ultimately, and is an iconic figure in African-American history. So here you have Justice Thomas. Let's just say that he's not as popular amongst African-American observers of American politics and law as had been Justice Thurgood Marshall. A lot of people call him a traitor. I can remember hearing, I'm sorry, I don't remember the name of this prominent African-American federal judge who sat in Philadelphia. He was on the Circuit Court of Appeals, I think.
Leon Higginbotham.
That's who I'm trying to think of. Yes, Leon Higginbotham, because as a young scholar, I was at Harvard back in the 1980s. Higginbotham was around there a lot, teaching at the law school and such. And then when Thomas was nominated, I rather think that the late Justice Higginbotham might have thought he should have been nominated, or someone rather like himself, to replace Thurgood Marshall, et cetera. So can you talk to us a little bit about the contrast between the philosophy of Justice Thomas? You've already stipulated that, or mentioned that it has its origins in this understanding of how the Declaration relates to the Constitution and the idea that rights are individual and not group oriented. But I'd like to hear more detail about that and how it contrasts with this more, if you will, liberal school of constitutional interpretation around issues of race and equality.
Okay, yeah. Thurgood Marshall obviously was probably the most important civil rights lawyer in American history. He argued and won Brown v. Board, among other things. And Justice Thomas is aware of that. Justice Thomas has great respect for Justice Marshall and the like. They simply disagree about the idea and the ideal of equality. Justice Thomas thinks that people should be treated as individuals and not as members of groups. And so on desegregation, for example, he thinks that Brown is about desegregation, whereas Justice Marshall thinks it's about integration. And that's different. So if you're committed to desegregation, that basically means that the government can't pass laws saying that the races can't mix. And of course, that's what Brown got rid of. But Justice Marshall wanted more than one. He wanted integration. And because of housing patterns and personal choices, the school systems aren't as integrated as some on the left, and when he was still alive and on the court, as Justice Marshall wanted. And that's just a difference of opinion. And in some of his decisions, Justice Thomas is very committed to the historically black colleges and universities. And he's afraid that if we go to this integration model, that those institutions are going to go by the wayside. And he thinks that would be a problem because they've contributed so much, including to educating people like Thurgood Marshall.
Now, excuse me for interrupting because I want to hear more about this, but it occurs to me that there could be a contradiction in Justice Thomas's thinking in this regard. If on the one hand he asserts Lockean liberalism, equal rights for people as individuals and not members of groups, and yet on the other hand he asserts communal institutions like historically black colleges being important and warranting to survive, and a certain diffidence toward the objective of racial integration because one respects the value of racially distinctive association. Is there a contradiction between the two? Individuals on the one hand, but communal associations on the other? Help me figure, how am I supposed to think about that?
Yeah, I think it turns on whether the government should assist in the maintenance of these historically black colleges and universities, for example. And he doesn't think so. He just raises the concern that they might go by the wayside. And what he's trying to do is rebut this idea that if it's separate and black, it's inferior. He doesn't believe that for a second. He thinks that Howard and Morehouse College and all of those historically black colleges and universities are wonderful institutions, and we have to realize that. But I also want to say this. Obviously, he knows that he's black, so he's sensitive to some of the implications of his jurisprudence. He's not unaware that people get discriminated against. He just disagrees about what the court's role in addressing that is, and also what the best approach to solving the problem is. Right? He thinks that people should be treated equally, that everyone should work hard and be judged on their merits. And if that happens, then everyone will be successful. He doesn't want African-American students to think that they can't get by without government assistance. He wants them to work hard, just like he wants me to work hard and all of that, and let the chips fall where they may.
All right. Now, those are all policy positions of that you impute to Justice Thomas, not matters of legal interpretation, because he wants these things. And this is back to my original point that ideological motivations may color the way in which someone reads the connection between a declaration and a constitution, for example, because they're trying to support a particular view about how they think society should be organized. In this case, Justice Thomas's view toward the right way for African Americans to respond to our condition in the post-emancipation U.S. Social and political order, that being one of getting busy, putting our nose to the grindstone, taking care of our own business, raising our children, building our communities and whatnot without reliance upon white people and so on. I don't want to put words in your mouth, but that's at least the spirit of what I heard you saying about Justice Thomas. And that becomes affirmative action is bad because black people shouldn't have to depend upon the largesse of white institutions in order to get ahead, or because recruiting all of the African Americans into white institutions ends up undermining or because ends up undermining the communal institutions of the African American society, or because the motivation for extending affirmative action to African Americans is a presumption that we are inferior or unable to overcome obstacles that we confront. All of these things are political and policy positions about which are arguable, not matters of high philosophy and constitutional necessity, or are they not?
Well, he says what I've described after he issues the legal conclusion, right? He'll go through and argue that the Equal Protection Clause is based on this notion that every person has inherent dignity and is entitled to equality, and we should be judged as individuals. But again, because he's aware that what he views civil rights to be, that is individual rights, not group rights, is controversial, given that he's an African-American male. He then goes on to explain why the policy judgments of the left, who he claims are trying to read their policy views into the law, doesn't work anyway. So the stuff that you and I are debating at the moment, he talks about after he's given his constitutional thoughts on it.
Okay, and we are supposed to believe that because he can walk and chew gum at the same time, because he can both do constitutional interpretation and social theory, that there's no necessary connection between the one and the other in his own mind, and that he's not looking for excuses in the law to justify his policy position.
Yeah, well, this goes back to my own thoughts that I mentioned a few minutes ago, and that is that I believe that you can't read a provision as general as the Equal Protection Clause, independent of philosophical views. And so what he does is consistent with that. He just happens to share the same philosophical views that I think the Declaration articulates. And so it's inevitable, in other words, Glenn, that he's going to do this.
Okay, now I got to ask you this, and it's going to come from left field a little bit, Scott, and I apologize in advance, but Thomas Jefferson was a slaveholder. Thomas Jefferson of Virginia was a planter. He held people in bondage. He trafficked in human flesh. He happens also to have been the author of the Declaration of Independence. I get that. He's a great American founder, but he was a slaveholder, not to mention Sally Hemings and her children. So where do we get off, or perhaps I should say, where does Justice Thomas get off on your reading of him, grounding his understanding about how to interpret the 14th Amendment's Equal Protection Clause as it bears on the lives of African-American descendants of slaves today, on the philosophical thought of a slave owner?
Yeah, beautiful question. And this is how, that he's committed to the principles that Jefferson articulated, not to Jefferson's practices. Locke himself trafficked in slavery. And so they're hypocrites. There's no doubt about it. But it's the principles that they articulate that the nation is committed to. And Lincoln famously argued that once the nation was strong enough as a union, we could then reconcile our founding principles to this awful practice of slavery that was inconsistent with it. And they all knew it was inconsistent with it, but it was simply convenient for them to have slaves wait on them hand and foot for free. That's a terrible thing that they did, right? But they were hypocrites to do that. Lincoln understood that. Lincoln said the time is now to do something about it, because the Union, he's going to try to keep it strong enough to get rid of that practice, and he did it.
Yeah, when Lincoln says in 1863, 7 years ago at Gettysburg, he's referring to 1776, not to 1787. He's referring to the Declaration of Independence, not to the U.S. Constitution.
Right, and if I might, I'd like to add one other thought. Ronald Dworkin, he's passed away now, but he was the leading liberal constitutional theorist of the 20th century. Yeah. He articulated a distinction between what are called concepts and conceptions. And that's what I've been trying to articulate. The concept is the ideal of inherent equality in the Declaration. The conception would be what Jefferson, as a hypocrite, thought it meant so he could justify having slaves. Dworkin thinks that the law should be about concepts, not conceptions. And I think he's right about that. I think that was a great jurisprudential contribution that Ronald Dworkin made. I'm
sorry, will you explain it again? Because I didn't follow the distinction between concept and conception.
Yeah, a conception would be my personal opinion about what equality means, okay? A concept is the ideal of it, and I could be wrong about my definition of it. So that's what he meant. So Dworkin's famous example was, he would tell his son, be a good man. Okay. And so Dworkin wouldn't want his son to try to decide what Dworkin thought that meant. He wanted his son to sort of figure it out and learn from experience.
Very Platonic, it seems.
Sure.
This ideal of a good man, or this ideal of equality, as distinct from the conception of it in the mind of any particular practitioner.
Right.
Okay. Do you remember, this might be before you were in graduate school, Scott, I think I might be older than you because I remember this very distinctly. The bicentennial year of the Constitution, 1987, Justice Thurgood Marshall is out in Hawaii, and he gives this speech, sitting Justice of the U.S. Supreme Court, about originalism, as I recall it, about a kind of the original intention or the original understanding or the original meaning. This was kind of contra Scalia. Was Scalia on the court by then? I think Scalia might have been on the court. Bork had been rejected, and Scalia had been elevated to the court. And who was a proponent of this philosophy of interpreting the Constitution in some sense through the original understanding or intention of the framers. And Marshall says, we've been fixing the Constitution from day one. He says, at first, you didn't popularly elect senators, people without property or women couldn't vote, blacks were not people, given Dred Scott, etc. We've been fixing the Constitution from day one. The Constitution is an evolving document. I put words in the late Justice Marshall's mouth, but this is the sense of it. I know this because, as it happens, I was in Bill Bennett's office. He was Secretary of Education in 1987 on the day that Thurgood Marshall gave this speech. And when aides came in, I was meeting with Bennett into the office and informed this, iconic conservative intellectual William Bennett about the speech that Justice Marshall had given. Bill Bennett went ballistic. He was beside himself with rage about the fact that a sitting justice of the U.S. Supreme Court in the year of the bicentennial of the Constitution would give a public address, in effect, quote, trashing from Bennett's, like trashing the Constitution. Now, I take it that Justice Thomas would take great issue with Justice Marshall's, late Justice Marshall's position there about the U.S. Constitution being a document that's evolving. Doesn't Justice Thomas have famously a sign in his chambers reading something like, I ain't evolving, something like that. I'm not evolving. And I take that to mean neither is the Constitution evolving. Can you speak to that?
Yeah, I'm not old enough to have been in school when Justice Marshall said that, but I read the speech and I know the speech, and it's a powerful speech, especially given who delivered the speech. And so Justice Marshall said that he's willing to celebrate the Reconstruction amendments, not the original Constitution. Okay, because of the horrible practice of slavery and discrimination in which the framers were engaged, in which the Constitution permitted by not abolishing slavery right out of the gate. And again, Lincoln explained that, and we can talk about that later if you want. But again, people are aware of the inconsistencies in the Constitution if we're a regime committed to this ideal of human dignity for everyone. And so what Justice Thomas does is he takes the Lincolnian position. He knows that Jefferson had slaves, and he knows that that was wrong. Okay, and the reason that Justice Thomas got interested in the Declaration in the first place was to try to understand how a country as great as ours could have treated African Americans so poorly, including his grandfather, who, along with his grandmother, raised him and had more impact on his life than anybody else. And so it was when he's trying to figure out these same inconsistencies that Justice Marshall articulated that led him to the Declaration, that then led him to Lincoln's writings about the Declaration and his speeches about the Declaration and all of that.
Okay. He's aware of the fact that there was a large gap between ideal and practice in the founding generation, that slavery was a blight on the Republic, but in the fullness of time, it was dealt with through the trauma of the Civil War, through Lincoln's leadership, and then through the post-Civil War Reconstruction amendments. So I guess the Constitution did evolve, did it not, through the amendment process in the direction of, to some degree, reconciling this ideal and this practice. But of course, you don't have an institution like slavery or a practice like the traffic in human chattel and the subjugation of people based on race. You don't have a practice like that widespread in the interstices of society without it insinuating itself in many dimensions of human intercourse, not only in the law. And because the law changes with a constitutional amendment at a point in time, doesn't mean that the stigma and the subjugation of these people as a matter of social practice is extirpated. We know that that's the case because 100 years passed after the Reconstruction amendments, in which the right to vote, equal citizenship, and so on, equal treatment, was not realized in large swaths of the United States. So I don't know if I'm buying this pretty picture of, it was messed up in 1776, but we got it right by 1867 or something like that, 1868, because what we might have gotten right, at least, was the law written down on paper, but what we certainly didn't get right was the social practice of equality as a matter of fact. We await the arrival of Lyndon Johnson and company to see some significant moves in that direction. So again, we're talking about Justice Thomas, not about you, but you're speaking for him here. What would he say about that little speech that I just gave?
Yeah, well, I'm not speaking for him. Obviously, I'm interpreting him.
That's what I meant to say.
Okay. I think he obviously would acknowledge that there's still discrimination in America. Everybody knows it. But he just, again, as a policy matter, he disagrees with the way that you solve the problem is by enacting these group-based remedies that the left wants. It hasn't worked. And then there's also this problem. What about the individuals that these group-based practices hurt, right? If, just before we started today's session, I looked at one of your earlier shows just to get the rhythm of it and all of that. And, you were given on a panel at Harvard with John McWhorter and all of that. And, you were pointing out that what the left wants hasn't worked. It hasn't worked for the African-American students that are admitted to Yale or to Harvard. You were at Harvard, I believe, that were not doing as well because of the mismatch bit. But it also doesn't work for people that look like me, right? I mean, I haven't discriminated against anybody, but I'm paying the price for these programs that the left has, whether it be in admissions to college or law school or university or to hiring and faculty slots and all of that. And I've, of course, written about that.
You didn't get the memo? You didn't get the memo, Scott? You're a privileged white male. I say that without the slightest degree of sarcasm. As a matter of fact, you are white, you are male, and you are therefore, at least in the minds of many people, privileged. And these activities like affirmative action and faculty hiring that may work to your disadvantage are necessary for the greater good of achieving diversity and inclusion in institutions and having them more effectively reflect the demographic composition of the population. What's your beef?
What's my beef? It affects the kind of life that I can lead. It also adversely impacts the students because they're not exposed to the type of diversity that we should value the most, and that is intellectual and ideological and viewpoint diversity, right? That's what education is about, right? I welcome debates with my colleagues on the left because that's about the only type of person I have to debate, because there's like a couple of us in law teaching that aren't on the left. But I welcome the debates when I have an opportunity to engage in them. But if there's only one or two people, the students are going to be indoctrinated, not educated.
Okay, well, that's a different subject than what we're here to talk about, but I broadly am in agreement with you about the importance of ideological diversity in the academy as a factor to make pedagogical goals more effectively achieved. I think debate is where we're going to learn and where we're going to grow, and a kind of closed off circle of mutual agreement and virtue signaling is, I'm on the record about all of that kind of stuff. But I want to ask you about, we've been talking about affirmative action implicitly here a little bit, and about Justice Thomas's emphasis on individuals. And individuals, of course, includes everybody, even you. Right. Your rights are no less important than are mine, notwithstanding the fact that my ancestors, some of them, were enslaved persons here in the United States. I just want you to know I know that. But what about the Voting Rights Act, which has been, quote, gutted by the U.S. Supreme Court in that case? What was it, Holder versus Hall or something like that? Where's Justice Thomas on that? Is that too a implication of his commitment to Lockean liberalism and the supremacy of individual over group rights? What about voter suppression? Stacey Abrams, amongst others, but she very prominently, close election in Georgia for governor, she lost, and has a piece on the op-ed page of the New York Times just a few days ago lamenting all of the various nefarious practices that she believes contributed to her defeat by suppressing the votes of people who would have supported her. This is possible because of the U.S. Supreme Court's interpretation of the Voting Rights Act of 1965, or reinterpretation of it. Some would hold President Obama and former President and former Attorney General Eric Holder are on a crusade to, as I understand it, especially Holder, to stamp out these kinds of practices and so on. Gerrymandering, minority districts, and so on. Can you speak to that broad area of the law, Justice Thomas's position within it, and how he justifies his conservative position in that area of the law?
Okay, sure. Justice Thomas believes that the right to vote is the right to cast a ballot and have it fairly counted. And I didn't read the op-ed that you mentioned by Stacey Abrams, but as you characterized it, I think he would support her concern, because that sounds like she's describing a denial of access to the ballot, or not having the ballot that was cast fairly counted. And so he would say that
she's saying voters were disqualified on technicalities from being able to cast. She's saying there were long lines at polling places because the resources were, she implies, intentionally allocated in such a manner as not to have sufficient capacity in areas where there was high turnout on behalf of her own candidacy and so on. Just want to put that in. So
if that was proved, he would, in my opinion, say that that's illegal. Okay, but that's what he thinks voting is, the right to cast a ballot and to have it freely and fairly counted. He doesn't think the government should be creating these congressional districts that guarantee that because someone is a certain skin color, that they're going to have a safe seat. That's not what the voting rights about. He also justifies his opposition to that because he doesn't think that African Americans all think alike. And this creation of majority-minority districts is premised on the idea that African Americans all think the same way. They don't. So he opposes majority-minority districts. He thinks that that's unconstitutional. But he also opposes the sort of vote suppression, if proved, that Stacey Abrams is describing.
Okay, let's talk about minority districts for a minute. It strikes me that I can remember Abigail Thurstrom's book, Whose Votes Count. Have you seen that book?
I haven't read it, but I know obviously who she is, certainly.
Yeah, Abby Thurstrom, a political scientist, right of center, I think you would have to say. And this is early on. This is the mid-1980s. She comes out with a book, Whose Votes Count? And she's making this argument that when you, during the redistricting process, create congressional districts that are intended to contain a majority of minority voters, of Black voters, with the objective of ensuring that an African-American candidate, a candidate of their choice, it's effective representation. It's not just titular representation that you get to go and cast the ballot. It's that the ballot ends up, in consequence, bringing someone to the table in the legislature who literally embodies your views, your aspirations. Well, no, not all African Americans think alike. Of course, that's almost axiomatically true, but there are such things as Black interests, the person here would articulate, historical, social, political, economic interests of African Americans. You can't just draw a sharp line between the racialized structure of society on the one hand, with segregated schools, segregated communities, racial conflict over resources and so forth and so on the one hand, and political representation on the other. We want effective interests. And Abigail Thurstrom was arguing as early as 35 years ago that no, that was mistaken. That I don't know if it was high Lockean individualism principle that was the grounding of her argument, but a kind of practical intuition that this is really not the way we want to organize our democracy. And I think, again, without imputing a view to her, she can speak for herself. That part of that was we want to encourage transracial or cross-racial political association. We don't want to see people as citizens primarily through the lens of their racial identity. We want to see them as members of unions or small business persons or farmers or religious persons or whatever. There are many dimensions to our human personality that could be the basis for political association. And it's not healthy for the republic to emphasize the racial aspect of our identity to the practical exclusion of all others when we start thinking about political representation. I always thought that was a very powerful argument. And when I saw the Georgia congressional delegation become very Republican over a period of a few years because all of the liberal African-American voters had been concentrated into a relatively few districts to ensure that a Black person could be elected to the Congress, I began to think, well, this is not obviously, even if I were to accept the premise that African Americans have interests that more or less align with the liberal political orientation, this is not obviously furthering those interests either. So anyway, I just thought I'd add that.
Yeah, just two reactions to that. One, Justice Thomas would agree with what Dr. Thurstrom said. He might have even cited her because he made the same point. Again, a policy point, I suppose, but his point was these districts would encourage a minority candidate to ignore the white voters in his or her district. And the same if you're one of the minority voters in a majority, a white district. The white candidate would simply ignore you, and that doesn't make any sense. And then the other part of it would be that, as everybody knows, I'm about to make the most obvious statement you've probably ever heard on your show, but Barack Obama is Black, and he won the election to be president of the United States twice, and the United States is not majority Black, so he must have persuaded some people that aren't Black to elect him president. So it is possible.
Yeah. Okay. I think we probably have to close in a bit, but I wondered if you could just tell us a little bit about the influence, the impact, the legacy. Justice Thomas may live for another 30 years or whatever, but, he's not going to be there forever. He's been there for a long time. He's had clerks who have fanned out. He's got presumably people appointed to the bench at the lower level in the federal courts who are in one way or another disciples or followers of himself. Can you talk a little bit about the impact of Justice Clarence Thomas's distinctive jurisprudence on the broader contours of contemporary American law?
Yeah, you highlighted one practical impact, and that is I saw an article, a newspaper article recently that said that 20% of the appellate court judges appointed by President Trump clerk for Justice Thomas. 20%.
Wow.
So that's a lot. The other part of it is, at least for me, and I've written op-eds about this before, and obviously the Declaration is the great statement of the American principles. And Justice Thomas is the leading spokesman on that document in America today, just like Reverend King was the leading spokesman in the 20th century with his I Have a Dream speech, and that was rooted in this promise of equality articulated in the Declaration. And just like, as we've already discussed, Abraham Lincoln was the leading spokesman of the document in the 19th century, and just as Thomas Jefferson, obviously, since he wrote it, was the leading spokesman about it in the 18th century. So that's quite a legacy, to be linked with Jefferson, Lincoln, King, and Thomas, to be the leading voice in America on the most important document ever written in America is quite a legacy.
Okay, well said. Scott Gerber, professor of law at Ohio Northern University and visiting professor here at Brown University. I really appreciate you giving us your time. Talk about Justice Clarence Thomas, an important figure in the history of American law, who deserves, in my view, to be treated a lot more seriously than he has been by much of the punditry. And I'm just Glenn Loury here at the Glenn Show, but I'm going to do my darndest to see that he gets a respectful hearing right here on this particular channel. So thanks again, Scott.
Well, thank you for inviting me, Glenn, and I enjoyed it very much.
Okay. See you then. Signing off.